Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a significant Supreme Court order delivered by a bench of Justice Vikram Nath and Justice Sandeep Mehta. This is the order granting bail to the promoters of Prayag Group in a money laundering case involving proceeds of crime of nearly 2,800 crores. But what makes this order particularly interesting is not merely the grant of bail, it is the searching questions the bench of Justice Vikram Nath and Justice Sandeep Mehta put to the Enforcement Directorate. The court repeatedly asked why the ED waited for almost a decade, which is 10 years plus, to register a fresh ECIR when the alleged crime dates back to 2013 2014. It questioned why the accused were not taken into custody earlier if the allegations substantially overlapped with the earlier prosecution. And even the bench remarked to the Enforcement Directorate that this is your problem. Why didn't you register it for 10 good years? The bench went a step further, asking, then you say that there has been continuous money laundering. What are you doing? Why are you sleeping? So the court also noted that despite filing of a prosecution complaint running into thousands of pages citing 29 witnesses, charges have still not been framed and there have been no likelihood of early conclusion of trial. Of course, all these details my panelists will share with you, but what we are seeing is a stance of the court on the whole issue of delayed prosecution and picking up cases by ED after a decade after first they were registered by the other agencies like the police or the Anti-Corruption Bureau. I have with me two experts who deal with this subject on a day-to-day basis. Advocate Arshdeep Singh Khurana, who argues at the courts in Delhi, including the Delhi High Court and the Supreme Court of India. Good to see you. Thank you so much for your time. I have with me Advocate Neha Nagpal, who routinely represents clients in cases involving the Enforcement Directorate, the SFIO, and also wide range of financial crimes. Good to see you, Neha. You join us from your new office for the first time. Many congratulations to you, and looking forward to recording many more from. And may this office will bode well for you. Thank you so much for joining at a short notice. At the outset, let me request Advocate Arshdeep Singh Khurana to give me a 3-minute explainer on this order by Justice Vikram Nath and Justice Sandeep Mehta. Then we dive into specific questions. Over to you, Arshdeep.
Yeah, so Tarun, this case, the history is that this, in fact, case is pertaining to a Ponzi scheme where a lot of money of investors were put into this company, and it was actually a multi-state case. Where Assam, you had Jharkhand, West Bengal, etc., were involved, and you had multiple FIRs which were registered over across the states, and the high courts had directed all these cases to be taken up by the CBI. That's insofar as the predicate offense is concerned. Then you had, of course, the ED coming in, the PMLA. Transactions pertain to 2013-14, and the accused had been in the total custody for 33 months, both in the predicate offense and about 16 months in the ED case. And three important highlights from the judgment: charges not framed, despite the case going on for a long time, and therefore the court concludes that there were 29 witnesses, and therefore there is no chance of the trial being concluded in the near future. So, and we've seen a whole line of judgments in the Honorable Supreme Court in the last couple of years, where the court notes that people are languishing in custody and the trials are not proceeding, and therefore bails are being granted, which is so delay in trial and bail is now a facet of Article 21. And despite the stringent conditions in PMLA for bail, we all know that the PMLA has these twin conditions where you have to satisfy a person is not guilty of the offense, effectively to get bail on merits. But Supreme Court says where there is a delay in trial, a person has been languishing in custody, there are no chances of the trial concluded in the future. Court says 21 has to be given supremacy, 45 has to step back, and bail is being granted. The other important principle was that one of the objections by the ED in this case was that the accused was still involving himself in money laundering and therefore was a repeat offender. But Supreme Court came heavily on that submission and said that none of the transactions of money laundering which the ED is alleging are recent. They're all of 2013-14. And what has the ED been doing over the years. And therefore, Supreme Court rightly granted bail to the accused.
Arshdeep, in the past few years, I have seen you have taken up cases of high profile accused involved in crimes who a lot of other lawyers refused to take up, given that the chances of getting bail was very bleak. Eventually, you successfully got them bail. Why I ask you this? That because the bench of Justice Vikram Nath and Justice Sandeep Mehta said, and this I consider the strongest aspect of this hearing, that they repeatedly questioned the ED over a 10-year delay in registering the fresh ECIR. How significant in your view are these observations? Do they indicate overall a judicial dissatisfaction with the manner in which the investigation is being conducted by the Enforcement Directorate?
100%, Tarun. And I mean, I've seen from, and I can say from experience, that you have firstly the investigations which never get over in ED. Multiple complaints are filed, and in every complaint, in the end, they will say our investigation is still pending and grant us liberty to file further complaints. So, a very fundamental issue, if your investigation is not complete, why keep a person in custody? The other important facet is that PMLA, the maximum punishment is 7 years. And we see cases where investigations span over 3, 4, 5 years. A person is arrested, trial is not commencing, and by the time he reaches the Honorable Supreme Court or even the High Court, he's already spent about a year and a half in custody. So a substantial time goes by for him then to say that now, the case is not proceeding, give me bail. And if tomorrow at the end of the trial or even at the stage of charge, he's discharged and he's found innocent, these years spent in custody are not going to come back. So I think the agency is to be blamed for this delay. Also, their complaints and documents are so voluminous that even for a court to proceed is very difficult, right? And now you have pre-cognizance hearing. There is a tendency of the agency making multiple accused as part of the prosecution complaint. So you'll have 30, 40 people in a complaint. Pre-cognizance service is not complete, Tarun. So investigation is not complete, service is not complete, and then there's an expectation that the accused will argue at the stage of charge. Documents are not given under 207, which is again a very important stage. Now Supreme Court says Article 21, right to fair trial, provide documents. All of this has now become a facet of 21. And we are grateful for the Honorable Supreme Court to give judgments like this. And so the agencies are to be blamed. And like I said, the years a person spent in incarceration are not going to be come back. There's no way to compensate. So
indeed a strong message by the Honorable Justices. I'll go to Ma'am Neha Nagpal. One thing that I want to ask you is that this bench noted that the alleged transactions relate back to 2013-2014. The accused have already undergone long periods of incarceration, which is they've spent time in jail in other connected cases, and charges have still not been framed. What I want to ask you is the court reaffirming that a speedy trial is an integral part of personal liberty, even in offenses like the Prevention of Money Laundering Act?
Absolutely. And not just money laundering. I think just this week, only 2-3 days ago, I think it's the same bench of the Supreme Court which has gone in a UAPA case, granted bail because of 12-year delay in trial to, even in that kind of a case. So what the Supreme Court is repeatedly saying is that personal liberty is paramount, is sacrosanct in terms of the Constitution of India. Two, one of the facets of Article 21 is also a speedy trial and a fair trial, because justice delayed is justice denied. So that I think the Supreme Court has repeatedly, in fact, even in the cases of bail, despite the twin conditions of bail, which is Arshdeep very correctly mentioned in the case of PMLA, there are twin conditions of bail even in SFIR. There are twin conditions of bail in NDPS. But in all those cases, one has seen repeatedly Supreme Court has started saying, I think, for a couple of 4-5 years ago, and with a lot more, focus that starting from K. Najib to Ghulam Nabi Azad and SFIO matter of Sujay Desai. Like, look, if charges are not framed, if charges are taking long, trial is taking long, bail has to be granted. This is a alteration in the position from the 2011 2G matter bails, where in the case of Sanjay Chandra versus CBI, Supreme Court had said wait for charges to be framed. But what has since happened is also the legal landscape has changed, with now pre-cognizance hearing coming into complaint cases, which is more typically a PMLA case or an SFIO case. Where before cognizance can be taken, you have to hear the accused, then cognizance, you have to decide on cognizance, then 207, and then charges are framed. So that whole process is delayed. And what charges, which earlier could be possibly if 207 compliance was done, there were fewer accused, charges could be framed in 4 to 5 months. Now that has become such a long path that you can't keep somebody in custody for that. Now, also there is this latest trend that one has seen in financial crime matters, that there are multiplicity of proceedings and multiple accused. So, and every accused's right is sacrosanct. Every accused's right is precious. You can't, for one accused being in custody, compromise on the other accused's right of inspection of documents or asking for underlied upon documents, only because one accused is in custody, and so you have to go to the stage of charge. So I think the courts are very conscious of that, and thus have repeatedly saying that, look, investigation is one thing, trial is one thing, and liberty comes above both of that.
Ma'am, I want to ask you a follow-up question on this. The bench of Justice Vikram Nath and Justice Sandeep Mehta said that the court should balance gravity of such allegations with constitutional principle that bail is not to be withheld indefinitely because the trial is delayed. This happened at a time when the ED argued that near 38 lakh investors were affected, and that the economic offences that are committed involving public money deserve a stricter approach. How does the court arrive at this balance?
Well, I think somewhere the agencies need to be pulled up and told that the onus lies on you. The onus lies on you to detect the crime, to instead of constantly prolonging investigation. Because what happens is, for charge sheet is not filed, say in 60 days, if the offence is for 7 years and less, you get default bail. Now, very many times agencies go file a prosecution complaint in that 60-day period so that default bail is not given, and seek liberty to go on with the investigation. It's the agencies who are dealing everything. The ultimate test, you can't process the punishment. Let the punishment be clear. Allow the investigation to finish in a timely manner. Look, legislature was aware and mindful that they gave a 60-day period, which is a lot of time. Grill people in those 60 days, get your prosecution complaints filed, stop running a process where you stretch a investigation to file supplementary complaints after supplementary complaints over years. That is the biggest problem today we face.
Point.
So I think somewhere it's the error lies not with the defense counsel or with the courts. It goes down to the agencies.
Point very well taken. I'll go to Arshdeep Singh Khurana. The petitioners argued that in the present ECIR, there was substantially a second prosecution based on the same facts, and that there was no distinct proceeds of crime. Although the court did not decide on that issue finally, do you think that this argument would have also influenced the grant of bail?
Has to be done, because I think in all cases where we see there is a major overlap between the predicate offense and the PMLA. Traditionally, PMLA was understood as an offense which occurred after the schedule offense was over, money was generated, and then it was laundered. Today, that distinction is not there, at least in the eyes of the agency. That distinction is not there. So you have the same offense or the same transaction being first investigated by the predicate agencies. They will take you in custody for that, and then once you get bail or you are in custody in that, the ED picks you up for the same transaction. So the transaction is not going to change. The facts are not going to change. So you have the same agency, two agencies investigating the same transaction and taking you into custody for the same transaction. The offenses may be different, but you see the purpose of custody on an arrest is to investigate. It's not to punish. Punishment happens post the trial if there is a conviction. But like Neha said, today the process is becoming the punishment. And one of the important facets of that is that you have the same transaction, two custodies for the same transaction for almost the same offense. There is no distinction today between the predicate offense and the money laundering offense.
I think one follow-up question to you, since your work largely involves doing these kind of matters. Uh, if you look at a wide range of cases involving financial crimes, do you think that this order by Justice Vikram Nath and Justice Sandeep Mehta will have implications in other cases beyond this present case? Secondly, could it also encourage other courts, which are the other high courts and the district courts, to scrutinize delayed ECIRs, second, overlapping prosecutions, thirdly, prolonged incarceration more closely in future PMLA matters? Could you give me a little detailed answer on this?
I think it will and it should, Tarun, because it's coming right from the Honorable Supreme Court, and in very clear words that if there is a delay, or even if the court assesses that the trial is not going to commence, see, for a court when it is looking at a bail application at a particular point of time, there may be already delay which has occurred. But I think what is more important for a court, and I think that's what the message comes from the judgment, that at that point of time, you need to assess, is it possible for the trial to conclude in the near future, or is it possible for the trial to commence? Is it possible for the court to hear charges in the near future? And that assessment is done on the basis of what is before the court. So there's a complaint, there are a number of accused, there are issues of service to accused, etc. So a court has to take a reasonable assessment of what is it, the court is looking at in the next 6 months or 1 year. And if the court says, look, I'm not going to reach the stage, and it is no fault of the court, it's the fault. One is the procedure is such, but majorly the fault lies in the agency. They don't finish their investigation, voluminous, records, number of accused. So the court has to do that assessment and say, all right, I don't think I'm going to reach a particular stage in the next 6 months or 1 year. Why should I detain a person in custody? It is better that the person is out. He is able to meet his counsels, work on the case, and the case moves on. So I think that's the very important message which this judgment gives. And I hope the honorable high courts and the trial courts, and they're doing that. I mean, we see a lot of advancement on this issue in the last 2 years, and we see at the trial court level also, and even at the a lot of honorable high courts are giving bail. They are not looking at the 45 scenario, and they're saying, look, there is a delay, and we are going to enforce Article 21, which is sacrosanct, and which is the highest of the fundamental rights in our system. Liberty is looked down as a very important facet of 21, and I think the courts will grant bail on this issue.
Point very well taken. One last question before we end. We're almost out of time. Neha Nakpal, I want to ask you, what is the message that this bench of Justice Vikram Nath, Justice Sandeep Mehta is sending by such an order, and the comments especially that they have made during the appearance that happened of the accused and also the Enforcement Directorate?
I think a subtly but very clear message is to the agencies that wake up, smell the coffee in a timely manner. You cannot keep dragging your feet. And it is in fact the same bench that I mentioned, the UAPA bail, 12-year delay. Article 21 of our constitution is the real founding stone of our constitution. We are not going to compromise on that. And I think time has come for the agencies to stop dragging the process at their end and complete the investigation in a timely manner. That will help unclog the system. That will also help a lot of assets which are stuck, because ED comes with attachments as well. A lot of this happens now. Assets get stuck for years and years because trials don't happen. Why don't trials happen? Because many times as defense counsel, we end up saying, but the investigation accused is pending, how can we frame charges? Now that becomes a conundrum both for bail as well as for assets remaining stuck. So I think if agencies hear this, read between the lines and really expedite their own internal machinery, things would start getting better.
Point very well taken. I would like to thank Advocate Arshdeep Singh Khurana, Ma'am Neha Nagpal for making time on this very important order by Justice Vikram Nath and Justice Sandeep Mehta, where they have upheld the principle of liberty and sent a strong message also to the agencies on delayed prosecution. That's why it was important to take this up. And of course, we would in future also take up such issues where the principle of liberty is being upheld by our courts and also delayed prosecution, which also remains important in the current times. Once again, like to thank our panelists for joining on this very important issue. Appreciate. Thank you so much.
Thank you for
Thank you,
having us,
Tarun.
Tarun.